Welcome to the National Inventor Club. I'm your host, Brian Freed, and we have a special edition today. With the U.S. Patent and Trademark Office, we have PTAB, Inventor Resources from the U.S. Patent and Trademark Office, and with us is Judge Stacey White and Judge John Schneider. Welcome to National Inventor Club.
Thank you, Brian.
Thank you.
Thank you. So there's a lot of questions about what PTAB is, what does it mean, all the different available resources for inventors out there. And today you're going to share that with us. So thank you. And before we get started, Judge Stacey White and Judge John Schneider, maybe you can tell us a little bit about yourselves.
Thank you. Well, my name is Stacey. My name is Stacey White. I am a lead administrative patent judge with the United States Patent and Trademark Office's Patent Trial and Appeal Board. I have been presiding over patent cases for about 10 years now. I have a background in computer science. I've worked as a software engineer prior to law school, and I've also worked as a patent litigator in large law firms before I came to become a judge here at the PTAB.
Very nice. Thank you. And Judge John Schneider?
Good afternoon. I'm Judge John Schneider. I've been with the board for about 6 years. Prior to that, I worked for a large number of law firms and one major corporation. But in addition to doing work for companies, I did have the opportunity to work with a number of small inventors who are starting out their careers developing new ideas that they had. While my background is in biochemistry, and I work on most of that right now, I've had the privilege of working in a lot of different technology areas.
Very
and
nice.
That's what I have for me.
Thank you very much. So let's get started and let's talk about all the available resources for inventors and entrepreneurs. There's different people at different stages of their invention and startups, and you have some great information for us. So let's get started from the U.S. Patent and Trademark Office.
Thanks, Brian. I think the first thing we'd like to do is perhaps explain a little bit about what PTAB or the board is and where we fit into the overall organization of the Patent Office. As you can see from the slide here, the PTAB is one of 4 business units within the Patent and Trademark Office, and we're one of the 2 that deal with patent-related issues. The major area, as you can see, is patents, which comprise mostly of patent examiners who examine applications and grant the patents. But then we have the board, which has been in existence for over 160 years in one form and another. Our role is to hear appeals from rejected patent applications from examiners, as well as challenges from the outside by individuals or corporations challenging an existing patent. Those are collected. The appeals from the examiner are referred to as ex parte appeals, and the outside challenges are referred to as AIA proceedings. And that's the bulk of what we do here. So when you run into a problem with your patent application and you feel you can't convince the examiner of the merits of your invention, one of your opportunities is to come before us and be heard before a panel of 3 judges who will have technical expertise in the technology you're working with.
Okay, so let me understand this, Judge. I file a patent. Most likely, it's going to be a utility patent application, otherwise known as a non-provisional patent application. So where application is going to be in front of a patent examiner, and
That's right.
When we wait until we end up getting an office action, there's something that happened in that office action to receive one, that certain claims might be rejected or certain things in our application might be rejected. And as inventors, we have an opportunity to kind of appeal that and see what and to challenge it. Is that right?
Yes. The normal process is you would first try, when you first get the first rejection, you would try to work with the examiner, either in writing or in person or a combination of, to try to convince him of the merits of your application and why it should be allowed. But if after that effort you get a second rejection, then one of your options would be to come before the board. You also have the option of trying to continue to work with the examiner, or if you think he's right about everything, of course, you can always give up and abandon your case. But hopefully you don't do that. You just continue to try to work with him or come to us to see if you can get your case allowed.
Understood. So as independent inventors, we're more focused if we did have these type of challenges to be in the PTAB box there.
That's correct.
Okay. Thank you.
You're welcome. So now we're going to talk about some of the resources that are available to inventors as they work their way through the patent office. Some of these relate to actions that you take before you come before the board, and others are things that we've developed to help you understand what goes on the board and to help you if you have to come before us. So the next slide. And we have two programs within the patent office that are called pro bono programs. And these are designed to help independent inventors with limited financial means in their efforts to appear before the patent office. The first one is run by the patent side of the house, and we call it the Patent Pro Bono Program. And there'll be a podcast coming up shortly that will have a lot more detail about how this works. But basically, there are programs located in different states and different parts of the country where they match up independent inventors and sometimes small businesses with volunteer patent attorneys who will help them prosecute their patent applications, at least up to the point where they have to come before the board or they get the case allowed.
And volunteer practitioners, that means patent attorneys or agents?
That is correct. And
Okay.
they will, now the independent inventors or a small business, and it's based upon an income level or being a small business entity, will have to still pay whatever fees are due to the patent office, but they will not have to pay for the attorney's time.
And sometimes if they do qualify for, there's different types of filings. So if they file as a micro entity, then the fees are substantially discounted.
That's correct.
Okay. And John, Judge John, many people have heard the term pro bono, but what does that really mean?
It means that comes from a Latin phrase. It's called pro bono publico, for the public's good. And so this is something to help the public, and particularly here in this case, the small inventor. And it's come to mean free legal assistance that's been paid for, or is being given free. It's the idea is it's helping the public.
Okay. And is the U.S. Patent and Trademark Office endorsing this program, or is it something available through independent volunteer practitioners?
We promote the program, but the actual coordination with who the volunteers that you wind up using are coordinated through each of the different entities you see listed at the bottom of this chart here. So for example, on the West Coast, you have the Washington Pro Bono Patent Network. Another one is in Idaho. If you're up there, there is an Idaho program. There's one for New York and New Jersey. There's a program. So there's about more than that. It looks like about 30 different programs spread around the United States. So you can come to the patent office, and then we will refer you to one of those programs, and they will then take it from there to help you find an attorney if you qualified to work on your patent application.
Okay. And when you say when we come to the patent office, how do we know about these resources? So let's say I'm an inventor. I want to file an application. I'm limited on funds. I discover that there's a pro bono program. What do I do next?
You can come. There is a space on our website, and here exactly is the link to the program that will take you to the page that you can use to get a referral from the patent office to each of these different groups. Also, if you come to our main homepage, there is an inventor entrepreneur resource section in there that you can find on the main page, and that will eventually lead you to the pro bono programs as well.
Absolutely. And I've seen it, and your website is well done and easy to navigate. So for anybody watching or listening, you can go to uspto.gov and you can go into the inventor resource area or inventor help area there, and you can pull down the pro bono program to find out more information. But you can just pause this also and write down this long web address here to get you directly to the program, but it should be easy enough on the website.
It is.
Okay.
Now I'm going to turn the mic over to Judge White because she's the one who's really done a lot of the work on the PTAB Pro Bono program and is our ace on that.
Thank you. The PTAB Pro Bono program is a separate program from the Patent Pro Bono program. This is a program that's going to help people specifically with appeals to the PTAB. So if you've been through the process of trying to prosecute your application and you've come to a point where you think that it's time for another set of eyes on this, I need to appeal and move on to the PTAB and not just work with the examiner here, this is where the PTAB Pro Bono program comes in. The goal we really have for this program is to sort of eliminate some of the financial barriers. Legal assistance can be quite expensive, and in cases where we can help people to get the assistance they need without having to pay those high costs, as John mentioned, you're still on the hook for paying the filing fees and such for the USPTO. But if you go through our program, you will not be paying the attorney fees, which can be quite costly in some circumstances.
Okay. So Judge White, this program is through the U.S. Patent and Trademark Office?
It is administered by the PTAB Bar Association. So unlike the Patent Pro Bono program, we only have one clearinghouse for the entire nation. So the PTAB Bar Association, you can either go directly to the PTAB Bar Association's website or to the PTAB's website, and I have the link to get to our website. And you will go to that website, and the PTAB Bar Association is the one and only entity that is handling getting volunteers and independent inventors matched up for legal services.
So PTAB, can you tell us what that stands for?
PTAB stands for Patent Trial and Appeal Board. As was mentioned earlier in this discussion, we handle both appeals, which is when you are coming to sort of loggerheads with the examiner and you really think that you are in a position where you need to get another set of eyes on your application, someone to review the rejections that the examiner has been making and to determine whether the examiner is correct in those rejections. That would be when you appeal to the PTAB.
Okay.
The other set of cases we have are AIA trials. The PTAB Pro Bono program doesn't currently handle AIA trials, but we will be expanding to that later. AIA trials are the circumstance when you already have an issued patent and there's a dispute about whether that patent should have been issued.
Okay. And AIA?
America Invents Act.
America Invents Act. Okay. Now,
perhaps I can explain. The American Invents Act created two methods for challenging existing patents. One is the inter partes review, what we sometimes call the IPR, and the other one is the post-grant review, or PGR, that a lot of people have heard about. So when we talk about AIA, we're talking about both those types of proceedings.
Thank you. And again, PTAB is when we filed an application, we've received some kind of rejection, most likely. We've hired a patent attorney or agent to help us possibly in the beginning. Now we're kind of limited on funds, or we're very tight on funds. And rather than going directly to our legal hire, we can sign up, or we can apply for the PTAB Pro Bono program, which somebody independently will be able to represent us and go through the claims and why we're having the challenge and if it could be overcome.
Yes. Maybe that's a good place for us to talk about who's eligible for this program.
Great.
Because we do have a number of criteria. The PTAB Bar Association is the one that examines whether the criteria are met by any particular inventor, but just to run through the things that they will be looking for. You need to be domiciled in the U.S., which means you just need to live in the United States. You have to have a household income that is no more than 300% of the federal poverty guidelines. As of right now, For a single person, that would be about $40,000, $40,770 to be exact. So if you are a single person, that would be your limit. But the larger your household is, the larger that number is. And there are some different numbers for folks that live in Alaska or Hawaii.
Okay.
And you have to be what's known as a micro entity. That is a status that was mentioned earlier that helps you to get a 75% reduction in USPTO fees. It's something that is it's a type of status that was created for the smaller inventors, for people that have not had, wide-ranging access to the patent system. You have to have had, for example, less than 4 patent applications filed, and you have to have had income within a lower limit. It's actually a little higher than our income for the program itself to be a micro entity. But once you're a micro entity, you get those reduced fees at 75% off on USPTO fees.
Okay.
And another aspect of this is timing. Timing is important because when you're in front of the PTAB, it's a legal proceeding, and we have deadlines and dates, and we don't want you to apply so late that you've missed a deadline or you've missed a date, and you're not going to have time for your volunteer attorney to work with you in the process. So the timing requirement that we've put on here is that within 1 month of the issuance of the office action that you would like to appeal, you need to apply to the program. So when you get that office action, it's the second time your claims have been rejected or it's a final rejection, and you're ready to appeal, please go on right ahead and apply for the program so that you can get in there within that first month. So that way you have time to get the application processed. It takes about a month for the application to be processed and for you to find out one way or the other whether you can receive assistance through the program. So that way there's still some time left to work with your volunteer attorney or agent to figure out what the next step should be in your appeal. And then the additional things that we look at is you need to have demonstrated knowledge of the program, the pro bono program itself, and the appeals process. And the way you get that is we have 2 videos available on the PTAB's website. One video talks about what the program is and how you apply, walks you through the website because it's all online as far as the process of applying. The second video gives you an overview of the ex parte appeal process, so you understand what the steps are in filing your appeal. So even if you are not going to go through this process and be part of the pro bono program, even if you're working with an attorney, you might get some value from viewing the training video on the ex parte appeals process, just to understand the steps in the process and what goes on in the process. So all these things are available on the PTAB's website free of charge. It's just available on demand. You just have to click it whenever you're ready to view it.
It's great that you're both on with us and being able to present these resources that are available to inventors. Many of us don't know about this, so hopefully people find out. Do you feel, from your experience in being active and helping in this regard, that enough inventors are taking advantage of these resources?
Well, that's why we're out here. We want to get the word out some more. I think that we are at the office trying to do a number of things to make the process a little easier to navigate. I mean, Brian, you've been through this several times. There's a couple places where it can be a little frustrating and challenging. And we've been trying to, as an office, come up with some ways to help people as they work through the patenting process. And we really want to get the word out so that people are aware of some of the services that we're offering to try and make the process a little easier to deal with.
Now, we heard both of your backgrounds. The patent examiners, so we file a non-provisional patent application. We filed design patent. The utility patent is the non-provisional patent application. The patent examiners that are reviewing our applications, what are their backgrounds? Where are they from? And how do they become a patent examiner?
Most of them will have a technical degree, if not an advanced degree, in the particular technology area that they're working in. And then they attend, and I believe it's a 4 month and maybe longer program within the office where they learn the rules that they have to apply to determine whether or not a patent is eligible or an application is eligible to become a patent. They then also continue to go through internal education processes. They work with a more experienced examiner for a while, sort of in an apprenticeship type program, if you will, until the supervisor examiner feels that they can start working on their own. But there's still checks on the quality of the work they do and the continuing education they're required. Many of them will also take advantage of the patent office's uh, education programs and will attend law school in hopes of eventually leaving the office and becoming a patent attorney. So they all have a strong technical background, and we try to give them at least the rudimentary legal background that they need to evaluate applications as it goes on.
Oh,
But that's why we have the board, which is comprised of experienced patent attorneys or people who were originally patent examiners who became lawyers and then became judges. But I think the probably average experience level is probably 20 to 30 years in patent law before they come to the board. So we've got our board is comprised of people who not only know technology but really know the law and can, as a check, to make sure the examiners are doing their job properly.
now all this really happens because we get this rejection. I mean, on the PTAB side. So most of the time, I had this experience that I would work with different patent attorneys and agents for myself and other inventors that I help, and most of the time the patent attorney or agent says expect a rejection. Now, how does a rejection happen?
The examiners will, the application is assigned to an examiner. He then looks at the written description that you've enclosed there. We call it the specification. He looks at the claims, which is what's the definition of your invention, in theory. And then he starts looking based on his expertise. He goes out and conducts a search, sometimes electronically. They used to do it manually. They would actually physically go through patents in a related technology and look for something that looked the same. And based upon that, he'll then formulate his opinion as to whether or not the case should be allowed, or if not, what the problems are. And this is where the opinion comes from. And it can be from several different areas. Sometimes it's the wording of the claims. We refer to that sometimes as indefiniteness or written description problems or enablement problems, because the patent has to teach other people how to perform the invention. So you have to enable is the term we use. It also has to describe the invention in a way that people can understand what you're trying to protect. So sometimes it's a question of the wording of the claims or the detailed description in the specification. Then we have what we often refer to as art rejections. These are the two types. It's anticipated. It's exactly the same as something somebody else has done before. Or obvious, given all the knowledge in this particular area of technology, that someone skilled in that field, seeing these different articles or different patents, would say, aha, all I had to do is take something from this one, take something from that one, and they would work together and I'd have the same thing. That's how the examiner reaches his decision, and it's usually structured first, saying where there is wording problems and then when there's art problems.
Thank you.
There are other types, but those are the major types of rejections you get.
I
Very
think in a
good.
nutshell, you should just really expect it to be a back and forth. Don't see a rejection, an office action as an end. It's sort of a beginning of the negotiation. In the vast majority of cases, you're going to get a rejection, and you just have an opportunity there to discuss with the examiner what you think is incorrect in that rejection, and perhaps maybe make some adjustments to your claims to get them in a place where you think you are claiming the thing that you've really invented.
Something that's probably not used as much perhaps as it should be is that it's possible to have a face-to-face conversation with the examiner. We refer to it as an interview, whether you want to actually go down to Washington itself and meet with them in person or do it either telephone or by video. All those are options to sit down. And then in some ways, if you can describe the background of your invention and how you came to it, and if you've got a working model, show them how it works. That gives the inventor, the examiner, a better idea of your invention, and he can better work with you to come up with allowable claims and get you your patent. And we actually have facilities in our regional offices if you don't have video capability. But if you can get to one of our regional offices, we have small conference rooms where you can set up a video link with the examiner and talk to him about your invention. So that is probably an underutilized aspect of the whole process. Is if you really think you've got some great gee whiz here, and like some of the stuff that Brian has shown us in his interview with us several months ago, taking it down or showing it to the examiner and how it works can really help impress them and show how earnest you are about your invention and make them want to help you.
Thank you both judges. Anything else you wanted to add, Judge White?
I wanted to add that there's no charge for using these resources at the regional offices.
Right.
So we have offices in Dallas, Denver, San Jose, and Detroit. And if you come out to any of these regional offices, you have both the interview rooms that Judge Schneider just mentioned, and there are some computer terminals there where you can do some searching on your own using the same exact tools that the examiners have at their disposal to see what sort of art is out there to help you in crafting your claims and making sure that you are not running into some of the things that are already out there.
It's very important for us. Well, I can talk for myself because I'm an inventor, but when we first start off, we're kind of naive. We're naive to the process and the workflow of how the application process works and what's included in it. That's why, even though I have 13 issued patents, I still use a specialist. I use a patent attorney or agent because it's a different language and anybody can learn it, just like anything can be learned, but it just takes time. And if you want to keep your invention, your idea moving forward, and you want to get some sort of intellectual property protection, then it is good to have this understanding or somebody representing you to be able to apply and be prepared. And I like what you said, Judge White, like expect it, but it's okay. And Judge Schneider, you mentioned like people are open to listening and being available to have an interview with you. And that's been my experience, whether it's been on the patent side and the trademark side, that they're pretty open to scheduling some time and discussing it. Whether they agree or not is a different story, but that's why we have you. We'll continue with your presentation. Thank you for that information, because it's kind of interesting to understand what actually is a rejection and also who the patent examiners are that are actually looking at our patent applications that we're spending quite a bit of money and trust on. So thank you for that.
You're welcome.
Okay. Well, to close the loop on the PTAB Pro Bono Program, as I mentioned, we have a single clearinghouse, and that's the PTAB Bar Association. The PTAB Bar Association is the one that's going to take in all the applications, and they're going to take in registrations from the members of the legal community that want to volunteer and help. And the PTAB Bar Association does the work of matching inventors and legal professionals up. It's also based on availability, so you could apply and they may not have someone available at the time. But the PTAB Bar Association is the one that does that work of putting together the volunteers and the inventors. Now, just so you know who these people are, as far as the volunteers, these are licensed, insured attorneys and agents. They have experience in technology similar to the thing that you're trying to work on your patent for, and they have experience in this type of proceeding. These people have all agreed to give you their services and to give you their time at no cost, and will provide you a representation agreement that outlines the types of activities that they will take up on your behalf, so that you know the scope of the representation, what they will do and what they won't do, and try and help you to understand what fees you could be looking at as far as USPTO fees or any other fees that may be a part of the process. All of that will be done in the conversation with your volunteer attorney right up front at the beginning.
For us as inventors, whoever we get assigned to, is there some kind of track record or almost like a way for us to look up or see the history of who it is that's representing us and how they've done representing?
I think that's going to be part of the conversation that you have initially with the legal professional that's been assigned to you. Just because the program says that you can work with, say, John Smith, you might talk to John Smith and decide that that's not a good match. You are still the client, and it's just like any other case where you will have the rights of any other client. They're not going to be out here just doing things. These attorneys are people that have volunteered to be helpful. And if it's not a good match for you, then it's not a good match for you. You are still in control and in charge of what goes on with your application.
Thank you.
And so just up here now is a website, a way to get to us. You can go through this longer website, or you could also go uspto.gov/PTAB Pro Bono, PTAB Pro Bono, PROBONO. And that'll also get you to our PTAB Pro Bono site, where you can find information as far as the videos I mentioned. It'll run back through all those criteria for eligibility and a link to where you apply to get into the program. So I just want to encourage you to keep this in mind. If you're going through the prosecution process and you get to that point where you think that appealing might be the thing you need to do, that there is a free resource here.
Okay. We've applied, but we've gone through the filing. We've had a couple of rejections. We're frustrated. We don't want to spend any more money on legal fees. We go through this process of applying for the PTAB Pro Bono Program, and we get assigned an independent person to be able to review our case. And then what happens next?
They're going to work with you on drafting briefs, getting the things before either the examiner or the board itself, depending on where you are, and getting your arguments in writing in the proper format. And depending on your case, if appropriate, they can have an oral argument where they appear in front of us arguing your case and your claims.
Okay. Anything else, Judge Schneider?
No, that's all I have.
Okay. Well, so far so good. I think we're keeping it nice and easy to understand. And the great thing about us having this online for everybody, whether they're watching or listening, the audience, they can stop it, rewind it, watch it as many times as they want it to be able to know that this information is available to them and how to go through the steps and the process to get it done. So far so good.
The next program we're going to talk about is another program for inventors to use to get representation at little or no cost. Again, it's the attorney time or the time being spent on it that'll be for no fee. You'd still be responsible for paying the fees to the office, but as we've explained, there are a lot of different scales of fees that can be paid, including the microentity status, which can get you substantial reductions in the PTO fees. But this is what we've called the Law School Clinic Program, and it's been around for a while now. And it is a cooperation between law schools around the country, as you can see, where they have a volunteer patent attorney supervising law students in becoming patent attorneys. So the law students may actually do it. It's like some of the other clinic programs you might have in, for example, some of the largest cities. They help with renters for having problems with their landlords. Mm-hmm. This is a program that's designed to give the law students real world experience in patent law and probably before the patent office, but with a experienced licensed patent attorney supervising the work to make sure they know what they're doing. As you can see, there are a number of clinics located all around the country. But the key here is that there are some programs that do both patent and trademark work, others that only do patent-only work, and a few that only do trademark work. So you need to be sure you go to the right clinic We here in Texas are fortunate all four of our programs do all the work necessary. And there's a large concentration, as you can see, back east, back home in New York, and around a lot of the major cities. Um, this is still coordinated through the patent office, but as far as eligibility, each clinic establishes their own eligibility criteria. So you'd have to contact those offices. But to learn more about the program, we have this website. Again, it's one of the really long ones, I'm afraid. But I think if you even used our search bar and typed in law school clinic, it would probably take you to where you need to go on that.
Okay.
This is, again, a free resource for as far as the legal work being done. It can be both for the application process and for the appeal process. So it covers both sides of that because you've got an experienced attorney running the whole program.
So those people who are in the audience listening without watching, you can go to uspto.gov and put in law school clinic, and the list of potential candidates to be able to help you. Same type of thing like the pro bono program on the patent side, but now this is actually with schools.
That's correct. And actually, we've got a program scheduled with you, hopefully next week, that'll go into this program in greater depth to explain to everybody how the program works, how you become eligible for it.
Excellent.
Another thing we've done, we should probably step back for a minute and explain something here. Although, as Brian has often said, it's often best to find a patent attorney or agent who can do work for you. I understand that some inventors still feel either economically or for other reasons why they prefer to represent themselves before the office. We tend to use that term as pro se, and I can't tell you the exact translation for that, but it just means the person's appearing on their own behalf. So we've designed some tools for those individuals who still want to make an appeal before the board pro se or as by themselves. Although these tools are also helpful for those of you who choose to use patent agents or attorneys and understand the forms that are going to be filed, what has to go into them. And then we have some education programs about how the law works, how we work, to try to take some of the mystery out of PTAB and who we really are. So we're going to talk next about some of those resources that we have.
Excellent.
It might be worth mentioning here that not every dispute with the examiner is something that you can appeal. Certain things have to go through what's known as a petition process, and other things can be appealed. The way to think about it, if you want to use the lingo that you're going to hear the examiners and even the judges using, is that objections are petitionable and rejections are appealable. And the way that that really breaks down is if your claims are rejected, say the art, there's something out there that the examiner says is either doing the exact same thing or would have made it obvious to do the thing you're doing, that's a rejection. If your claims are written in a way that the examiner doesn't think that they are capturing patentable subject matter, that would be a rejection. If you have something like the examiner doesn't think that the form of your drawings is correct, that's an objection. That's not the type of thing that can be appealed. But your substantive issues about what's going on with your claims are, for the most part, appealable issues, and those are rejections that you can bring to us either via your attorney through a paid services, the pro bono program, or working on your own with something like this appeal brief tool that Judge Schneider's about to explain.
Look, I've had many patents that have been applications that have been rejected, and I've had multiple times. And if I knew about this, to me, I might as well take a shot and see if I can overcome it. But honestly, sometimes I didn't do a good job doing a patent search before, or I didn't have somebody else do a good patent search for me enough to not just make it look the same. Like I have something and somebody else has something. and they just look the same, but the functionality of it, the utility, the claim of what I'm putting in, somebody didn't find. They just didn't go, they didn't spend an extra 5-10 minutes to find that one that was out there. So the patent searching is very important, I think, as an inventor, to really, just like starting a business, you're doing your research and development. This is a little bit different of the research to see who your competition is, or what intellectual property is out there that's similar to mine, and is it enough of a difference to be able to call my own? Otherwise, I'm going to stop and move on to my next idea, or I'm going to take a chance. It might be some cost to doing that, and some objections and rejections and some pain to try to get there, with the possibility of getting it or not. But at least being able to have this available to us is something interesting. But I strongly suggest to the inventors that I speak to, when they just come up with an idea, not to just go through and start this process of filing a patent application, but having some expectations of knowing from the beginning what they might be facing. And that's an important part of everything that you all are doing, which we very much appreciate. But the start of it is, what do we do as an inventor first when we have that idea, so we don't have to be involved in this?
For that piece of it, we do have resources in our regional offices. As I mentioned, there are search terminals in the regional office where you can use the exact same databases and libraries that examiners have at their disposal to try and see what else is out there. We also have resources available at libraries around the country. They're called PTRCs. So if you go to the USPTO's website and you search for PTRC, you will find that listing of libraries around the country where they have search terminals available, and librarians who have been trained on this. So that's a resource that's out there and free and available to the public to do some of this background work, because as you've mentioned, it's quite crucial to know what else is out there when you're trying to go through the patenting process.
Yep, that PTRC is Patent and Trademark Resource Center, and that's a great resource. There's many libraries should be around by you, and you can go to them. You schedule an appointment. They will help you to pull prior art and to take a look and understand the claims, but they're not legal advisors, and they're not going to answer the question of, what do you think of my invention?
I've been around long enough. I remember when the PTRC in the New York Public Library was on West 48th Street, and actually had to print things out from a microfiche printer. But yeah, they've been around a long time, and they're an extremely useful resource. I think there's one in almost every state, if not every state.
Excellent. Okay.
So on the appeal brief tool, the next slide, what we've done is we've made available a Word document template, which is the guideline for completing or filling out a brief, an appeal brief to be filed with the board. It has all the different sections that are required under the rules. Accompanying that, here it mentions a PDF, which gives you instructions and explains what needs to be included in there, each of the different sections. And there's also a video that goes along with it. So you can sit down with this template, download it into your computer, and then following the instructions there, write out what needs to be put in all those sections. And I think even if you have an attorney or an agent working with you, this would be a useful tool to understand what information you might need to give your attorney going forward in drafting this appeal. And you're going to make it a much more solid brief technically, because you're the one that really understands your invention. And if you spend some time reading the references that the examiners rely upon, chances are you're going to have a better understanding and help your attorney draft good arguments to be able to present to us to overcome the rejection. So for both the person who wants to appear by themselves, come before us, and we've had a number of those, or the person who has an attorney, this is a good tool to understand what information we're looking for when you come before us, at least in the broad brush strokes of the types of information we use.
Okay. Can you also just pause for a moment? Because we've mentioned patent attorney and patent agent. Can you just help us to understand what the differences are with those two types of
Surely. A,
practitioners?
a patent agent is usually someone who does not have a law degree, but has a technical background and has taken the agent's exam, as we call it in the office, and is registered to practice before the patent office. He's only licensed to practice before the patent office. He can't write contracts for you, can't write a will for you. All he can do is things before the office. A patent attorney is someone who is a licensed attorney and can do work outside of the patent office. So, for example, before I came to the board, I was registered as a patent attorney before the office, but I was also licensed to practice in New York, Texas, and Colorado, as well as several federal courts. So I wasn't a patent attorney. My father, when he first graduated college and went to work for a law firm, was a patent agent. But when he graduated from law school, he became a patent attorney. Kept the same number, registration number, but he just shifted his title from agent to attorney.
And many patent agents that I've run into are some type of engineer.
That they have usually the requirement to sit for the exam is that you have either by education or experience a technical background. Interesting enough, when I first applied, biology wasn't on the magic list of sciences, but I had had enough chemistry and physics credits to be able to sit for the exam. Obviously, that's changed, but that was the rule. And it was really funny because I actually had to go get my old course catalogs and show them the details of the courses I took, which included organic chemistry, physical chemistry, also biochemistry, and all that other stuff. But biology in 1984 was not on the magic list of sciences.
Thank you for that.
I had the same thing with computer science. I had to prove up computer science.
So the list evolves, but
Understood.
yes, you're right. They will have a technical background. I actually worked with a lawyer, a patent lawyer in one of the first firms I worked for. His degree was actually in music, but he learned electronics from wiring together soundboards and everything else, and was able to demonstrate a practical experience in electronics and was allowed to sit for the exam.
Very, very good. Thank you for that. So a patent attorney is somebody that went to law school and they can litigate on our behalf in court. A patent agent is somebody that has been registered with the U.S. Patent and Trademark Office to communicate what we're looking to do with the patent office on our behalf, and cannot go into court, but can really be able to communicate and understands what they need to do to be able to help us to get a patent as well. So
And I hate to say it, they usually charge a lot less money.
you said it, not me. But
But
yes,
the attorneys that practice before us also are registered, so they have to go through that same examination and
Yeah.
also show the technical background. So everyone that's practicing before us as a registered patent attorney or a registered patent agent has been through that process.
thank you. Okay.
So here we have the link to the appeal brief tool. There is a quicker way to get there if you come to, and we'll talk about that in a little bit as one of the other resources. We have a web page called New to PTAB, and included on that page is a direct link to the appeal brief tool. But
Okay.
for those out there, again, that's a very long address, you might want to pause and write it down, but you can also search for appeal brief from the PTO main page at our search site there.
Okay.
We've also tried to develop some web programs to help educate inventors and actually anybody who's interested in learning about the patent process. And there's two basic programs we have here. The first we call the Inventor Hour. This is a monthly hour-long program. Brian actually honored us by giving us some time, about 20 minutes, and it was a fascinating program to listen to how he came and how he developed his inventions. But during these programs, we try to give the public, and particularly inventors, some information about how we operate. There will be a portion of it devoted to appeal part of the process. There will be a portion that will be devoted to the AIA trial work. But we'll talk about a lot of different topics. For example, Judge White was talking about what can be a petition versus what can be appealed. That was a segment in one of our PTAB hours out there, and with the more detailed explanation of how you make that determination. There will also be discussions of what constitutes what we call obviousness, or what constitutes anticipation, the legal standards for obtaining a patent, and some of them deal with procedural aspects. What do you do? Like, how do you write an appeal brief? What types of information should you put there? If you're coming in to make an oral argument before us, what should you expect when you arrive there, and what type of conversation should you have with the judges? It's one thing if you do decide to do it by yourself and you come in to appear before us in person. This is going to be a conversation. The judges are going to have questions, and they're going to engage you in a conversation about your invention. And so this is part of what's going on. We're trying to learn what's going on here. We have the prior episodes of these recorded and available to us. And one thing we are working on, we're going to start to try to put an index to help you more easily figure out what's in the different episodes, because now you'd have to go to each episode, pull in that full details box that's over there in the corner, and that'll bring up the agenda and decide whether you want to watch it or not. We've got enough of these now. I think we have about a dozen of them. We're going to start trying to build an index and put that on the website so that you can click it and say, oh, well, I wanted to see what they said about petitional matters, or I want to see what they said about oral arguments, and you can click that and just go to those things, or at least tell you where to go. The next one we have is a little bit more in depth, and it's called Boardside Chats. This originally designed more for the practitioners out there, and they focus on one specific topic. But again, they're open to the public, and if you really want to learn about the patent process, you're welcome to join these. Again, they're held about every month, sometimes a little more, and it's a deep dive into a particular area. You get a lot of information there. Again, it's a long hour, and it's more of a conversational type aspect to it.
Well, there's a good amount of information that's provided there. You're talking about having an inventor or resource for inventor that's shared, and resources that are available from the PTAB, from Pro Bono. Very interesting. So you can see the agendas of them and find topics of interest, and know that you always have, and that's the purpose of us doing this presentation today, is to show and understand the resources that are available from this division of the U.S. Patent and Trademark Office.
And we're trying to get more out on social media, particularly in LinkedIn and in Facebook, to let people know that it's out there. And we'll have the broad agenda as part of that announcement, so you can decide, is this something I want to come and look at? But you're certainly welcome to, and it's like with Brian's podcasts, listen to the sections you want. If you've got the information you want to had and you don't want to stay for the rest of it, that's fine too. But everybody is welcome. And as they say, within a few weeks after they've been given live, they are available for people to look at through the PTO website.
Thank you.
The last part we have here is we're going to talk about is what we call our new to PTAB webpage. It's a way to stay informed what's going on in PTAB. And here we have links to tell you what PTAB is about, what the ex parte appeals, which we've talked about, a little bit more about AA proceedings. As you can see, we have a link to the Boardside Chats. We're going to add in some more information about the Inventor Hour program and the ex parte brief template. And I believe there is a link to the Pro Bono program, maybe more deeper embedded into the appeal part of the process.
Yes.
The other thing we're doing for this page, which we're really excited about it, and we're one of the first parts of the Patent Office to do this, is we're translating it into about a dozen different languages. It's currently available in English, German, and Spanish, and we're adding, I don't even have the list. I know Chinese is in there. We're working on Japanese, French, Italian, Hebrew, and several other languages that we think are common for people to do. So we want to be able to reach as many people as we can in their native languages, because we know a lot of inventors are not necessarily native English speakers, to let them know about what's available to them and what we can do to help them. And with that, I think that covers most of what we have for you, Brian.
That's fantastic. Really some great information. Any final words for us inventors that are kind of hanging on, just trying to figure things out from the beginning and just understanding and knowing that we have resources that are available? I mean, we might see you in that, I guess, arbitration type of environment, not necessarily through the steps before that, but you've kind of seen it being in the seats that you're in to just help us with some final words. You've given us a tremendous amount of words during this presentation, but just some final ones to keep our minds going.
So the office really wants to support the small inventor, the entrepreneur, the person that's working out of their garage to just build that next new thing. The United States, our economy is based on this innovation, and you're important to us. So we're trying to put out these resources to help you navigate this process. So stay encouraged. We know that it can be frustrating if you are not used to the system, but we are trying to put these resources out here in an effort to make it a little bit easier.
Thank you. And Judge Schneider?
Yeah, I would say don't panic, be patient. Really, we're here to try to help you. We can't represent you, obviously, but we want to be able to give you the resources you need to be successful. And as Judge White mentioned, the whole purpose of the PTO is to encourage innovation, and we want to be able to help you, the small inventor, succeed, go forward with your ideas, so you can then hopefully monetize them, preferably through licensing or whatever process you've got, or take it your own and start making them yourself. We want to support you, and we want to make sure your rights are protected. That's really what our all about is. That's so that you can go forward and be successful in your process, your commercialization.
Thank you. USPTO.gov is the place for all the resources that you need from what we've spoken about today, but also there's a section on there for inventors and entrepreneurs. There's a new section called PTAB to help you through that process if and should you need it. And we have to just keep moving forward with our ideas and doing our due diligence, our research, and getting the right information out. And that's why we've done this today. So thank you both for your time and for your information and for supporting the independent inventor.
Our pleasure.
Thank you
Thank
very
you.
much for having us.
Thank
you.
you. Thank you, everybody, for joining us. You've been watching a special presentation from National Inventor Club, the PTAB inventor resources that are available from the U.S. Patent and Trademark Office. Please join as a free or a paid member to National Inventor Club and stay tuned for more interesting presentations like this from the PTAB and from the USPTO. Thank you, and we'll see you again soon.